So we're going to talk about the various ways that the lawyer can control and use the predilections or biases or leanings of the jurors and bring them around to your viewpoint. And there are definite psychological principles that apply. And these principles are very much in our control to some extent. And the ones that are not in our control, we'll talk about how to deal with them. The first and most important one, what I call the spotlight theory, that the jury will focus in deliberation where the spotlight is placed during trial. The jury will focus in deliberation where the spotlight is placed during trial. Now, the important thing about that is that's called the availability bias or the availability principle. Jurors will talk about the information that is made available to them. And if you fail to make available information that they need, you've left an evidentiary gap, you leave room for bias. So the spotlight theory is extremely important because we can use it in every single case we have by deciding what information we're going to present to a jury and where we're going to put it. Are we going to use it in primacy and recency? Are we going to raise it on summation? Are we going to raise it in opening and come back and reconfirm it during summation? The various ways that we can provide data are the consummate use of the availability principle. For example, I'm going to show you now 6 cards. You're going to see them for 3 seconds, and I want you to pick one card. Focus on one card. Okay? If I got you to focus in the right spot, your card has now disappeared. The reason it's disappeared, focus. What you do with the availability bias is you get the jury to focus where you want them to focus in the evidence. And so when you're preparing a case for trial, one of the first things we always do is establish what are our most important points. What are the points that we have to have the jury focus on in order to prevail in this case? And then what are the points that the defendant is going to want to focus on? And then we have to determine how to neutralize the data that they're focusing on. But choose first your availability bias. With the availability bias, for example, you want to focus on the plaintiff's reasonable conduct. It is not enough today, in this age of tort reform, it is not enough today to prove that the defendant was negligent. That used to be all we had to prove. Not anymore. Today we have to prove the lack of negligence on the part of the plaintiff. We have to prove positively, bring forth evidence that the plaintiff acted reasonably, as a reasonably prudent person would have acted under the same or similar circumstances, and that there was lack of negligence. So you want to focus on the plaintiff's reasonable conduct, their lack of negligence, and then the focus, obviously, on the plaintiff's damages. So that's one aspect of the availability bias. Now, on the other side, you want to focus on the acts of the opponent. You want to focus, if it's a corporation you're suing, you don't sue a corporation. They can't get their minds around the idea of a corporation acting negligently, because a corporation, or especially grossly negligent, because a corporation is a piece of paper on file at the Secretary of State's office. You have to put a human face on a corporation that you're suing as a defendant. And you do that by focusing on the vice principals of the corporation, the officers, directors, decision makers, board members, or if there's a specific person within the corporation. For example, if you've got a defective design case as we had against General Motors on the rear-end collision fuel-fed fire, we focus on the specific designer who made the decision that he was going to leave that gas tank located in that particular spot rather than move it to a safer position as they had done in the same model of truck. So we had a specific individual to focus on, and that's what you need to do. So you're putting your focus on the opponent's acts, and if it's a corporation, on their principles. Now, this is extremely important, and you'll hear this come up over and over and over, and there's very, very, very good reasons for it. You reframe defendant's negligent acts into positive actions, and even more importantly, into positive choices. You don't want to say the defendant failed to do this, and they failed to do this, and they failed to do this. You want to talk in terms of and offer proof in terms of the defendant chose to do this. They chose to act in this way. And there are reasons for that we'll talk about as we go through these principles. You have to show the unusual nature of the defendant's actions. In other words, you're testing a defendant against what a reasonably prudent person would do under the same or similar circumstances. So in order to get them out of that norm, you actually prove not just what the defendant did, but you offer proof as to what a reasonably prudent person would do. Time was when we didn't have to do that. We'd just say that the defendant acted in this way, and everybody would agree, okay, that was negligence, and we'd move on. In this age of tort reform, you have to prove the reasonable conduct of the plaintiff, and you have to prove the standard against which the defendant's conduct is being measured, whether it's driving within the speed limit, whether it's stopping at a red light, whatever the reasonable conduct is, compare that to the unusual nature that the defendant did, which was different from what a reasonably prudent person would do. Extremely important point. We always sit down with a brainstorming session, and we try to determine what were all of the choices that the defendant had in this case. What could the defendant have done that would have avoided this outcome, avoided this tragedy? And you list every single one. It doesn't matter what it is. If it's a doctor, if it's a medical negligence case, what other courses of action could the doctor have taken which would have accomplished the end goal without having visited this tragedy upon the plaintiff? If it's a driver, they could have turned to the left, they could have turned to the right, they could have applied brakes, they could have slowed, they could have chosen early not to drive at such a high rate of speed, they could have chosen not to go through the red light, but they chose instead to try to speed up at the last minute and make that red light. This all comes back to the power of choice. You want to control the juror's focus with the availability bias, and by doing that, visual aids are absolutely indispensable. This is how you use graphics. This is why you use graphics. You use it to control the focus and to make your information available to the jury in the order and with the emphasis that you choose to make it.